Hello, ladies and gentlemen. Welcome to what was supposed to be the AGM. For those of you who came specifically for the AGM, we've got a very special surprise for you. We're not actually going to have the AGM today. That's going to take place in April. Instead, we have probably the most illustrious panel that RISA has ever put on. And to go with that, we also have the most illustrious audience we've ever had. A very special welcome to Lady Arden, Mr. Justice Cawley, Mr. Justice Seagal. Very good to see you here. The panel today, we have some regulars and then some new faces. From right to left, Mr. Michael Pearson, who you all know is a director at FFP, who regularly is involved in cases involving arbitrations. Sitting to Michael's left is Lord Mance, a former judge of the Supreme Court of the United Kingdom and served as the Deputy President of the Supreme Court between 2017-2019, now at 7 King's Bench Walk Chambers in London, and regularly takes appointments as an arbitrator. Next to him, Megan Paget-Brown from Paget-Brown Chambers, English qualified solicitor, Cayman admitted attorney, and admitted in several states in the United States, specialising in civil litigation and alternative dispute resolution. And then to Megan's left is Tom Lowe QC, who we all know appears regularly in the Cayman courts as a leading advocate and appears regularly in arbitration proceedings. And so the panel today is international reflections on arbitration with a Caymanian perspective. And at that point, I'll hand over to Lord Mance to lead the panel.
Thank you very much indeed, and welcome. I'm privileged to chair the panel, and our first speaker, who I think will go directly to the heart of the matter and tell us about the Cayman Island arbitration position in particular, is Megan Paget-Brown. Now, I don't have your CV in front of me. I have it somewhere on this iPad, but it is extremely distinguished, highly qualified in a number of jurisdictions. If you feel the need to tell the audience more, I don't think it's necessary myself, but I'm delighted to be with you. And excuse me for not having your CV in paper in front of me. Megan.
Thank you very much. I think we can skip past any more bio and focus more on the meat of the issue here and focus on arbitration and the Cayman Islands. Delighted to be here today. I can certainly say if someone had told me as a child that I was going to be at a Regal Cinema on TV with lots of people watching me, this isn't the scenario I would have imagined for that. But nonetheless, it's a privilege to be here on such a distinguished panel, and especially to be here in person with you all today. I know time is short, so my plan is to just briefly highlight a few points that I think are of particular interest relating to arbitration law here in the Cayman Islands, sort of to start that out as a jumping off point for any Q&A we might have later on today, and wrap up, with time permitting, with a brief update on where we're at with plans for the International Arbitration Center here in Cayman. With clock ticking, just start with the arbitration law as a whole. The arbitration law was updated in 2012, and it made great strides to making Cayman a much more attractive jurisdiction for international arbitration. It addressed some key weaknesses that were in the old law, such as the ability of the court to continue proceedings despite a valid arbitration agreement. The law here is based on the English Arbitration Act of 1996 and provisions of the Institutional Model Law, the 2006 revision. It supports and protects party autonomy, which is a cornerstone of arbitration, and is based on 3 fundamental principles, which are the fair resolution of disputes by an impartial tribunal without undue delay or expense, limits on the scope for court intervention, and flexibility for parties to agree on how their dispute is to be resolved. From a comparative perspective, there are lots of resources that detail the differences between different institutional rules, which is important for institutional arbitrations, but I thought for this discussion today it would be more interesting to look at a brief comparative analysis of some of the laws of the different seats, which is of note for ad hoc arbitrations, but also using Cayman as a jurisdiction for disputes. So I will just briefly touch on a few elements of the law that I think are of particular note. Obviously, could spend a very long time doing it, but I know everyone would rather get to drinks at the end. So despite being based on the English Arbitration Act, there are some key differences between the Cayman's law and the English law. One important departure is in relation to the doctrine of competence, which is related to a tribunal's ability to rule on its own jurisdiction. In the United Kingdom, parties are able to contract out of that doctrine, and that isn't the case in Cayman law. The tribunal holds the right to rule on their own jurisdiction, regardless of what the parties agree. There are very few restrictions in the law on which types of disputes are arbitrable, at least in a broad sense. The law states that it must not be contrary to public policy, and it must not be incapable of determination by virtue of any other law in the Cayman Islands. In a very general sense, matrimonial and criminal disputes are not arbitrable, and most commercial disputes are. Just because something is arbitrable in the commercial realm doesn't mean it necessarily should be arbitrable, and I know that that will be discussed in more detail later. One particular area that I think is developing in the law is in the area of winding up, and I do think that is discussed further later, so I'll just bring that up as a brief point, that is a developing area that is going to be of interest. Another particular area where I think the Cayman law has shown a lot of foresight and is sort of ahead of the game, or has been ahead of the game, is with regard to default procedures. The law does leave it predominantly free to the parties to determine how they want to determine their disputes, what processes and procedures they want to use, but there are some default rules that can come into force and help in the absence of agreement between the parties. One of the shortcomings in many arbitration laws is that they are based much more closely on the UNCITRAL model law, which didn't contemplate a situation where there might be multiple claimants and/or respondents, and refers only to one claimant and one respondent. The Cayman law has taken a much broader approach in at least some instances, where it refers to two or more parties. And some of the other jurisdictions have started to see, with the increase in third parties being added to disputes in arbitration and joinder, that they need to amend their laws to address that. I think in 2020, Singapore was one of the major seats to amend their law and sort of take that into account and more explicitly provide for multiple respondents and/or multiple claimants in these sorts of situations. Cayman has also set itself apart from many other jurisdictions in that it makes confidentiality and privacy an obligation. Many institutional rules make it an obligation or requirement, but there are fewer jurisdictions that have it guaranteed in the same way that the Cayman law guarantees it. This can be of particular importance in dealing with trusts, which is also a topic for later today, and other areas where it could be particularly important would be perhaps intellectual property disputes that deal with trade secret, or some joint ventures, technology-related disputes involving blockchain, cryptocurrency, private keys, and other areas where confidentiality is paramount. If in the course of an arbitration proceeding in Cayman, the parties need to make an application to the court, they have the opportunity to ask for any hearings to be in private, and can ask for, in certain circumstances, either there be no publication of the proceedings or there be a time delay. Particularly in maybe joint venture scenarios, you might be okay with some of the information being released, but just not immediately. You need a certain date to pass, and there are provisions for that in the law. One of the major areas of sort of difference in some of the national laws internationally are with regard to the finality of the award and the ability to appeal or challenge. And one of the hallmarks or fundamental ideas of arbitration is that there should be the final power with the tribunal to make an award. And so typically there are very limited grounds to challenge an award or have it set aside. In Cayman, errors such as computational errors may be corrected by the tribunal. But there are very limited grounds for challenging an award, such as incapacity, duress, or an invalid arbitration agreement. There are some opportunities, if there's a particular question of law, to apply to the court, both here and I believe in the United Kingdom, on those questions of law. And if leave is granted, the court may confirm or vary the award, remit it to the tribunal for reconsideration, or set the award aside in whole or in part. That isn't true of all jurisdictions, and there can be quite a variety of approaches in the finality of an award and the ability to appeal it or challenge it. Particularly in civil law jurisdictions. In Germany, the German court can only set aside domestic arbitration awards, not international. In France, the parties can have an award set aside in whole in very limited circumstances, but the court cannot make an assessment on the legal or factual reasoning of an award. Similarly, in Spain, an award may be declared null and void on a limited number of bases, but there cannot be a rehearing of any of the merits of the case, and you can't present questions of law in the same way you can in Cayman Islands. The assistance of the courts is paramount to an appealing jurisdiction for international arbitration. Although party autonomy is very important, you do need the support of the courts, and that is certainly the case here. The court does have certain powers to assist the arbitration proceedings, and they may compel disclosure from third parties, order a person to attend the court and produce certain documents, and they have just other general powers to support arbitral proceedings. One instance where that might come up is there's no provision in the law to appoint an emergency arbitrator before a tribunal has been appointed, but the court, through their power to issue interim measures in the key is urgent circumstances in the law, may sort of step in and help in those emergency proceedings. Interim relief is an area that we brought up and discussed some earlier this week, and it is available under the law. I believe it's Section 8, and it does provide for the preservation of assets or evidence, or interim relief to prevent harm or prejudice to the arbitral process, and to maintain or restore a party's original position pending determination. Preliminary orders, which are temporary in nature and expire after 20 days, are binding on the parties but are not enforceable by the courts because they're not a final determination, whereas other interim measures that are considered to be a final determination are then enforceable by the courts. That isn't necessarily true in all jurisdictions, and in some jurisdictions there are potential questions raised about if if the measures aren't final and there's no enforceability, what steps can really be taken, and that was one of the points of critique of the 2006 revision of the institutional model law. And I think the Cayman law has done its best to address that issue with the distinction between an interim measure and a preliminary order and that finality and enforcement question. In a case where there are foreign proceedings in certain appropriate circumstances, the court may also issue anti-suit injunctions if there's a breach of the arbitration agreement and subject to the jurisdiction. And security for costs is another area that can vary depending on the rules you're under. The local laws in Cayman, security for costs may be ordered in some circumstances, but the law does clarify that it can be ordered merely because a claimant is an individual that's ordinarily resident outside of the islands, or a corporation or association that's incorporated or managed outside of the islands. You do need some more of a compelling reason to ask for the security for costs. One other area of law that I'll just mention very briefly that some countries have made certain amendments recently to involves work permits. And in the Cayman law, there is an exception to work permits for people who are attending or providing expert opinion to arbitration and court proceedings as long as it's less than 10 days. And there's also sort of a catch-all provision where if there's permission from an immigration officer of a certain level, you can come in for some of these purposes without a work permit as long as it's for a narrow purpose and under a certain number of days. Other jurisdictions, the BVI, I think a year or two ago, also amended their immigration law to make it more attractive to bring in experts and other foreign practitioners for arbitration. I suspect I'm running a little bit long on time, so I will just wrap up with a brief update on the Cayman International Arbitration Center. Some people may have been aware that right before COVID, we were in the process of opening an arbitration center here in Cayman with the idea that it would not only help support domestic arbitration and mediation and other alternative dispute resolution here on the island, but also help attract international arbitration to the island. And unfortunately, due to COVID, we weren't able to continue with our plans in early 2020, but now the island is open again. We are looking to try and open hopefully later this year, or certainly sometime early next year. We will hopefully be opening here in Cayman Bay. We're still looking at some different space and different options, but the idea will be to have a neutral location with facilities that are designed specifically for hearings, of breakout rooms, support for technology, whether it's an in-person, a virtual, or a hybrid hearing, and to offer training and other support for practitioners here on the island. Additionally, we would like to offer our own set of rules for Cayman-seated institutional arbitration down the line. And I think fundamentally we truly believe that Cayman should be up there with Singapore and some of these other jurisdictions. We have supportive courts. We have an excellent model arbitration law here in the Cayman Islands, and great weather, great beaches, excellent geographic convenience for the Americas. And I think that we can really see how, with the particular expertise there is here on the island in the financial services, technology, that Cayman can really set itself apart. And so we're very excited to get things going in with that, and hopefully we'll have a better timeline of when that might open within the next couple of months at the latest. So I look forward to sharing more information on that when it's available. So thank you very much. I know that was a quick run through, but hopefully it gave a little bit of a framework of some of the comparative issues, at least that I see, relating to arbitration in Cayman, and sort of started things off for a more detailed discussion on some more particular issues here. Thank you.
Thank you very much. And my next, the next speaker is Michael Pearson, who's an independent director, liquidator, trustee and advisor, a chartered accountant, and a Cayman Island qualified insolvency practitioner, and specializes, I understand, in liquidation, in which connection he may have a greater connection with litigation than arbitration, but it will be very interesting to hear his perspective. Michael.
Thanks very much. So in terms of the user experience of arbitration is what I've been asked to talk about this afternoon. And I did a little bit of a ring around some of my sort of fellow insolvency practitioner colleagues, and to be honest, there's not a huge amount of arbitration experience on the island, and I was scratching my head a little bit. I've done a few over the years, but really no more than a few. I've only ever really used arbitration when I've been obliged to do so. I've never really viewed it as an alternative to conventional litigation. And so in preparing for this panel, I perhaps approached this historically from perhaps a narrow-minded point of view. And I can now see some circumstances where it will be beneficial to consider agreeing to arbitrate rather than litigate. I think from a Cayman perspective, it could be perhaps a small volume of quite significant cases that will be what we're aiming for. Most of the disputes I see do tend to litigate. Formal mediation is rare. I'm in a mediation at the moment, and I don't have a particularly positive experience of that either, I'm afraid. But I wonder if there is merit in, as an island, in sort of exploring again in a bit more detail some of the alternative dispute resolution tools that are out there. But I appreciate that's beyond the scope of today's panel. So From an insolvency practitioner's perspective, if I sort of wear that hat for a moment, some of the perceived benefits of arbitration, I think, are perhaps less important and actually could be even disadvantageous in a lot of insolvency situations. Typically, what I see as being typical claims in arbitrations will be against service providers. So it will be in the context of suing an auditor, suing a fund administrator, perhaps suing a law firm. Occasionally, directorship firms or trust companies, they tend not, by and large, to have arbitration clauses. But certainly those firms with big brands, big reputations to consider, have already thought about dispute resolution, and they value the privacy that comes with arbitration. So some of the issues, speed is often touted as one of the primary benefits of arbitration. You don't have to work around a busy court calendar and the availability of judges. And I think there is some merit to that. I think perhaps less so here because we do have a broad bench, and it doesn't take long, in my experience, to get into court in Cayman as compared to other places, particularly New York and London as well. So I think that speed is perhaps not everything it's cracked up to be. Good arbitrators are in demand as well and are often booked up a long time in advance. And from an insolvency perspective, I'm not often making decisions based on speed. Usually a liquidation has many work streams, not just one litigation. Perhaps there's several litigations. There's often complex creditor claims to agree and difficult assets. So often a liquidation is a multi-year exercise. So knocking the lights out on an arbitration result in the first year is often not called for. And of course, we're often coming in and having to develop a case from scratch. And certainly in an arbitration, I don't think you really want to be able to put your best foot forward. Of course, you need quite a lot of time to do the discovery and the records recovery. One of the other benefits that is often touted is the privacy, the confidentiality. And as I've said, the big brands, big reputations to protect, value arbitration. I've noticed as well, if there's some real scoundrels out there, they also value arbitration. Again, for the privacy reasons. I think Tom and I are involved in one at the moment, but I probably shouldn't say more than that. I think Tom is going to make a point later about trust arbitration, which I think that in Cayman that could actually be, I think, a very interesting development. Certainly, I've noticed quite a significant difference, and it perhaps took a little while for the penny to drop. That where you have private client cases, they often value privacy over and above everything else. So they're prepared to give away the leverage of publicity. They're prepared to give away perhaps the benefits of discovery that might come through conventional litigation, because over and above everything else, they want it confidential. So it's a different approach, and I wonder if that is an interesting opportunity for the arbitration centre here in Cayman. The next point that I wanted to talk about is the appeals in arbitration, or usually the lack thereof. Often the stakeholders in the engagements I get involved in, be it a liquidation committee or general counsel in a family office, although they are educated and sophisticated in finance, they're often not sophisticated in litigation, and so their emotional attachment and analysis of the case is often a constant battle. And so I think a lot of stakeholders do derive a lot of comfort from the fact that there is a court of appeal and the Privy Council, particularly in very high value litigation, which is often the kind of litigation that we see here in Cayman. Because of course the consequences of incorrect decisions are more profound if there's no ability to appeal. I will say from my own experience, I don't have a particularly good record on appeal, particularly in front of Lord Manson and Lady Arden. So I think on that basis, I perhaps should do more arbitration. So I think a counter argument to that appeals point is that if you have a particularly specialist issue, then you can actually get three with enough time and contacts. I think you probably can get three subject matter experts, and hence there is less risk of being upset at the arbitration ruling and the lack of appeal, because there's a lot more expertise and depth in the arbitration panel. That's not to say for a moment that our FSD judges lack expertise or depth, but I think I'll refrain from any more comments on that in case I go off script like I did once before and upset one of the judges. The next point is cost. Now, all litigation is expensive, and I'm sceptical that arbitration will in fact be really any whether it will be significantly cheaper. I mean, perhaps the more limited discovery will assist in keeping costs lower, but there's also, I think, less scrutiny of costs in an arbitration, and so it's sometimes often easier for the other side to run me out of budget. I mean, I'm often on a wing and a prayer in terms of funding in most liquidation and an arbitration context. And in terms of trying to attract funding, I think the litigation funding market is also generally a little bit wary of arbitrations, and I think that is partly because they like to see a case develop and evolve, perhaps have some early rulings, and then quite often it's actually once you're actually quite a long way into the case that you can actually start to attract the significant funding, and usually it's the law firms or the insolvency practitioners that are providing the credit to get the case to that stage. I think with an arbitration, it's all or nothing, and so you're going to end up with some very significant costs in a very compressed time frame, and I think persuading a lot of the professionals to invest that amount of risk in a sparsely funded case is difficult. Final point on costs is obviously a strong panel of arbitrators, including venue hire and travel costs, is going to be significant. It's probably going to be north of $5,000 an hour, and that's not just the time when they're sitting in the arbitration centre. It involves all of the preparation and any skirmishes that happen on the way as well. So you need to be properly funded to go into arbitration. Last couple of points from me. The informality, I think that can be a bit of a downside. It's a little bit of a personal bugbear of mine. Quite often a defendant in a litigation is slithering around looking for any opportunity they can to not play by the rules. So I derive a lot of comfort personally from having a thick rule book and a judge with a firm backhand to keep people in line. And I do wonder in arbitration if it is more difficult for the panel to compel sort of some of those good faith interactions. In terms of the only other points that I wanted to make was, Megan has talked about the new arbitration centre, the quality of the venue, the accommodation, the IT and everything, and there are a number of very strong arbitration centres around the world, and I think it will be difficult to compete. And so I wonder whether the way for Cayman to compete going forwards is to focus on perhaps very specific types of arbitration. Certainly getting to the Cayman Islands over the last couple of years, like many places, has been difficult. It's opening up now, but why come to Cayman in a way when you can go to Miami or New York or London? I think that's something we're going to have to really think about and address. So I'll finish off by saying what are the kind of suitable cases for arbitrating. Well, professional negligence cases quite often end up in arbitration because whoever the director was of the investment fund years ago when they signed the engagement letter wasn't focusing on the dispute resolution clause. And so when you get appointed as liquidator sort of 2, 5, 8, 10 years later, you're forced to arbitrate. I think it's hard to envisage willingly choosing to arbitrate a negligence case, I would think. perhaps you'd mediate it ahead of arbitration. I wonder if some valuation-based claims would be suitable for arbitration. So, for example, not situations where there would be a binary outcome. I think I would be much more comfortable going down an arbitration route, knowing that I was arguing over an amount that was not going to be zero. So that's perhaps something that might be appropriate. I think fraud is difficult to arbitrate. Trust disputes, as we said earlier, could be I think an area to focus on. And for me, I think it's very much a case of this has been preparing for this panel has sort of opened my eyes a little bit in terms of looking at some of these alternative measures. Because I think perhaps here we have historically just focused on court litigation. So it might be time as an industry to sort of reflect on what some of the other mechanisms may well be. But one of the things that certainly there is going to be one change coming to my own business as a result of preparing for this panel, which is to actually change our engagement letters so that it's an arbitration clause if anybody wants to sue me. I'm not going to let that get played out in court. So I think that's all I'm going to say for now. I'll pass back or pass over.
Thank you very much indeed, and I think we'll follow up some of those points in a moment. If there are any questions from the audience, you could shout out in the middle of the talks, but if there are none, we will continue with Tom Lowe. Tom, you've been a silk here for a number of years, 8, did you say? 12, sorry, having come from London. I don't think I have a CV for you, but no doubt you speak for yourself too.
Thank you. I've been asked to be very brief because, and I'm not going to talk about trusts, and I'll resist the invitation that Mr. Pearson gave me, but this is a subject about certain types of dispute that you arguably shouldn't arbitrate. The talk's prompted by the Privy Council giving leave to appeal from the Cayman Court of Appeal in a case called Family Mart, you might have heard of. Mr. Justice Caverley decided that a winding up petition, a just and equitable petition, was fundamentally arbitrable, and the Court of Appeal decided it was fundamentally not arbitrable, and now the Privy Council has predictably given leave to appeal. Can we have the next slide? The problem for arbitration straight away is that the relief that you can get in the winding up relief is a relief that only a court can grant. It's not relief any arbitrator can grant. It's a statutory remedy, and only the court has jurisdiction. The second problem is that there's quite old authority, a case called Peveril, the English Court of Appeal, that you cannot limit the right to obtain winding up relief. And so the first case that grappled with these issues was, in England, was Fulham Football Club, at an appellate level that is, and the decision in the Court of Appeal was that fundamentally an unfair prejudice petition is an inter partes dispute. It's clearly, there's no reason, public policy reason why it shouldn't be capable of arbitration. Of course, some of the relief that can be given, but by no means all, most of the relief can be given by arbitrators, but some of the relief can only be granted by a court. You can get a winding up order, unfair prejudice proceedings, for example, and you can get, you can't get third-party relief in unfair prejudice proceedings. So there are some things that a court would have to do. And that led to the idea that you could have bifurcation in shareholder disputes. You could have the dispute arbitrated and the relief dealt with separately by a court. The way that they dealt with Peveril was to say, well, you can't limit the statutory right, but you can agree not to present a winding up petition. And because in England, just and equitable petitions are so similar to unfair prejudice petitions, we can't see any reason why you couldn't arbitrate those either. And since we can't just say they're arbitrable, we'll say there's an implied agreement that you don't present a winding up petition. So that then, just to complete that, you have a case called Salford Estates, which is about a creditor's petition, which established essentially that a winding up petition is not a claim. It's not an inter partes claim. So you can't have an automatic stay of the petition. You can have a discretionary stay, and save in exceptional circumstances, you'd get one. The first case that really, at an appellate level, deals with the question whether you can arbitrate a just and equitable petition was a case here called Family Mart. And the Court of Appeal decided, as I said earlier, that a winding up petition, just and equitable petition, is fundamentally not arbitrable, and that the court wouldn't bifurcate, it wouldn't hive off the dispute and then let the court decide the form of relief. And that was principally because the court has to be, under the statute, it has to be of the opinion that it is just and equitable to wind up the company. It's only the court that can form that opinion under the statute. And lots of companies laws all around the world that followed the English model and the old English Companies Act have that same wording. The decision has to be made as at the date of the winding up order. So you can't have an arbitrator dealing with it 6 months before the relief, because the court has to know all the circumstances that apply at the date of the winding up order. And that was recently confirmed by Lady Arden in a Privy Council case. And the third reason was that the court needs to take into account all the circumstances, and it can't just leave that to the arbitrator and delegate it. The Family Mart was recently considered in England by Mr. Justice Foxton, and he said about it, really what's on the screen, what he said was it's not arbitrable because the whole process has to involve the court. So that's where we are, and that's going to be the subject of the Privy Council debate, and I hope there's no one here from Maples going to ask any questions, because I won't answer them. Where does that leave the solution to Re Peveril? What happens about agreements not to present a winding up petition? That's quite interesting, because here in Cayman we have a specific statutory provision that recognizes the Re Peveril argument. The court has to dismiss, and it's mandatory, has to dismiss a petition or adjourn it on the ground that the petitioner is contractually bound not to present a petition against the company. In Family Mart, that meant that the Court of Appeal refused to follow Fulham Football Club and imply an agreement not to present a petition. Why would you imply an agreement when the statute gives you an express choice whether or not to do it? So they said no. They didn't say you couldn't have an express agreement. And interestingly, there's no appeal from that decision to the Privy Council. So that particular reasoning is not going to be the subject of challenge, although I dare say it might be debated. And so the question really is, if you want to draft an agreement, you can put it in the articles, or more usually in a shareholders agreement or joint venture agreement. You want to present draft a provision not to present a petition, you have to be careful, because if you do it in perpetuity, then it might be said, well, you'll fall foul of Re Peveril in substance, because that's really in substance not giving someone the statutory right that they're entitled to. So the question is whether you can do something a bit more temporal. You don't know, of course, what kind of arbitration is going to be run. You don't know if it's going to completely decide the dispute. And you just, all you can really do is agree not to present a petition while there is some process in play where the parties decide whether or not to arbitrate. You give them a time to do that if there's an arbitration clause. But otherwise, it's going to be difficult to have a permanent agreement not to do that. I don't know if anyone's come across that or whether you've seen it in articles. The only articles I've seen in arbitration, where I've seen an arbitration clause in any case discussed, is the old chestnut of Hickman and Kent about the statutory contract, but didn't really debate the form of the clause in the articles. And that's really, I hope I've been brief enough.
Brilliantly brief, but very interesting. I don't know whether it's appropriate or not to... anyway, I wish you a fair hearing in the Privy Council. Whether you have a fair wind or not will no doubt depend on the merits. Well, thank you very much. That's very interesting, I hope, start to the debate. Let me just add some comments of my own. The fundamental difference, of course, between litigation and arbitration is that courts exist because of the exercise of a state's sovereign power within its jurisdiction, and are on call to exercise that power even if the defendant in particular doesn't like it, whereas arbitration operates consensually, party autonomy being the leitmotif, although, of course, as was mentioned by, I think, Megan Paget-Brown, its effectiveness does derive generally, at least in the world as we currently know it, from recognition by domestic courts. Emmanuel Gaillard, Professor Gaillard, whose sad death recently occurred, would suggest the contrary, perhaps, under French civil law, but that's not the common law view. Arbitration has grown exponentially, and it's relevant to ask why and whether it's always a good choice. It hasn't always been welcome, of course. It used to be viewed with suspicion by courts, and Lord Chief Justice Thomas gave a famous speech a few years ago regretting the absence of court authority because of the growth of arbitration. I'm not sure it's a frightfully good argument, but it is true in some areas. There is regret, particularly in the maritime field in London, that there is not more court authority. And there are still areas, I mean, under German law, arbitration of consumer disputes is not permitted. And rather remarkably, the European Court of Justice has recently put the boot in a big way into what are called intra-EU BITs, in other words, internal bilateral investment treaty arbitration between member states. But I think that's a bit outside the scope of today, where we're concerned with commercial arbitration, not arbitration by investors against states. There are, of course, areas which have been touched on this evening where arbitrability is questionable. We've just heard Tom Law talk about the winding up area, and he didn't go into it, but mentioned also the trust area. The main problem in relation to trusts is that it's not usually easy to involve or be certain that you've involved all concerned, in particular beneficiaries, and in particular if they're underage, cannot have arbitration imposed on them by trustees or settlors. They have to agree, and if they're underage, they can't. And whilst I've heard and taken part in an interesting seminar in Singapore on the subject, I think arbitration in relation to trust disputes is something which may be attractive to settlors, but is quite difficult to arrange on a comprehensive basis involving all concerned, which is what would be necessary. In truly contractual contexts, of course, arbitration has undoubtedly become the primary method of dispute resolution over a wide range of areas. And I think there are two reasons, and one might be slightly cautious about each of them. The first reason is general business or market reasons, and that really touches on the idea of a local arbitration centre. Of course, it's attractive in market terms to, in particular, lawyers. It brings business, it's good business, and that is evident from the operations of the established arbitration centres, whether they're London, Paris, Zurich, Geneva, Hong Kong, Singapore, or New York. And there are also newer arbitration centres, Mauritius, and there's talk of a centre in the Bahamas as well as here. But they do take, as I think Michael Pearson said, money and time to develop, and one must ask the questions which Michael asked. Would they generate business, and if so, why? There are ample facilities offered, as I've indicated, elsewhere in the world. And indeed, there is a growth of commercial courts, as we know. Not the London Commercial Court has always held itself out as offering an international service, but you've got Singapore, you've got Middle East common law courts, you've got a Central Asian court I actually preside over, and there are moves within the European states to try and offer a more international service. So it's a pretty competitive world, although it may be attractive for those who operate professionally in it, by which I mean business in a general sense and the legal profession. You are trying to set up something which you have to ask whether parties would subscribe to. Now, it may be they would subscribe because, as I think Michael Pearson indicated, arbitration clauses, one suspects, get into contracts very often without those involved thinking very much about it. Michael said it's hard to envisage a professional willingly choosing to arbitrate a negligence case. Well, I express no view on whether that's so, but I do think it is probably right that people put arbitration clauses, and in particular drafters, put them in, and the actual client doesn't really focus on what it means. So one ought to focus on what the differences between litigation and arbitration are, and many of them do derive from their different nature. Courts can do lots of things that arbitrators can't do. They can bring associated disputes together much more easily. They can join necessary and proper third parties. They can enforce their orders in a way which arbitrators can't always do. But the problem about arbitration is that you have to have consent, as I mentioned, and you can find situations where you have a series of annual contracts, each containing an arbitration clause. They can't even be brought strictly in the same arbitration, or it may be difficult. Now, there are international rules, institutional rules, which do allow, to a greater or lesser extent, joinder of connected issues, but certainly not all institution rules permit this, and ad hoc arbitrations, obviously, by definition, don't operate on any institutional rules. And when you have such arrangements, they also risk impinging on one of the perceived advantages of arbitration, the ability to choose your tribunal. If parties C, D, and E are simply brought into the scope of an arbitration started between parties A and B, they will have had no scope, no choice to choose about the identity of the tribunal. And if they have a choice and can select a different tribunal, then the very most you can hope for is two arbitrations held before different tribunals, but contemporaneously and in the same room, which is a pretty cumbersome exercise. And various attempts are made sometimes. For example, if you've got a series of insurance contracts underwritten in different percentages by different insurers, the insured may understandably appoint the same arbitrator in each of three arbitrations, if there are three of them. On the other hand, the reinsurer may well prefer to keep the arbitrations apart and appoint a different arbitrator. And the chairman then may or may not be the same chair, and there may or may not be objections if, on grounds of potential bias, if the same chair is proposed. And indeed, there may be objections even to the appointment by the insured of the same arbitrator in all three arbitrations, because it may be said that that arbitrator has specific knowledge of the second and third arbitration, which that arbitrator may use in the first arbitration, and that is unfair on well, it's contrary to the general principle that you don't use information gathered in one arbitration in another. So these are potential problems about arbitration which need to be thought about sometimes. The choice of arbitration is often advocated as an opportunity to enable parties to select individual members of a tribunal. Of course, the primary advantage is that you can be sure that you're not going to be dragged into some unattractive court in an unattractive domestic jurisdiction. That's an advantage which shouldn't itself be overvalued, because a choice of court agreement also, generally speaking, has the same effect. Of course, there are perhaps differences of enforcement. The New York Convention is a stronger guarantee of respect for your arbitration agreement than perhaps any international convention relating to choice of court clauses. Perhaps one day the Hague Choice of Court Convention 2005 will become equivalent when it had enough subscribers to the New York Convention, but at the moment it isn't. But the second advantage, as I've mentioned, is the inability to select individual arbitrators, and that can be valuable when some specialist areas in issue. But it does strike me occasionally that and it is evidently a prized feature, but I'm not always sure for very good reasons. It's said that there is an a program which you can find and buy on the internet called arbitral intelligence, or which enables you to understand the propensities of a particular arbitrator. The logic of that is that each party should buy it and the two purchases should cancel each other out. Anyway, I'm pretty skeptical about the ability of others to predict my own usually unpredictable decisions. So that I think there is a huge amount of sensitivity about appointments as arbitrator, and I think perhaps I'm overconfident as a judge, but one really perhaps shouldn't be paying quite so much attention to the supposed proclivities of individuals. Obviously, if somebody is incompetent or extremely slow, you want to avoid them, but subject to that, as I said, I'm a bit skeptical. What about other factors? Well, confidentiality is undoubtedly a plus for arbitration, but speed, informality, control over procedure, costs. I think Michael Pearson said some wise things. The fact is that nowadays, in particular, and though one may regret it, it is probably the case that arbitration has very little edge at all on litigation. Obviously, one values the ability to drink coffee during an arbitration, but I'm not sure that's really a very good reason for choosing it. As to speed, I did actually recently hear at a conference on arbitration promoted by one speaker as a means of delaying the evil hour. Now, that may be an exceptional view, and I certainly hope that it is, but the fact, as Michael mentioned, is that good arbitrators are much in demand, and they can find it very hard to give early dates or write quick awards. And while Michael referred to busy court lists, the truth is that commercial courts operate on a basis of transposability. Different judge may deal with different interlocutory stages of the same case, whereas in arbitration, the arbitrator, or the arbitrators, the tribunal, all have to focus on every stage of every case, however minor and procedural, however much you wish you had a master to which you could pass some of these tiresome disputes about time extensions and so on. So there is perhaps another side of the picture to the usual lauding of arbitration as speedy, informal, and I think Michael also mentioned the slightly greater control which courts have over procedure. This may be largely psychological, but it's not entirely, because some institutional rules make express the fact that it is open to parties to agree procedural timetables or steps which the tribunal must accept. Other institutional rules operate on a basis rather like submitting a matter to court. Once you give it to the arbitrator, you just accept whatever rule the arbitrator makes. But where you have a rule which expressly says that the party's decision is binding, then the arbitrator is strictly, although you can try and influence the parties by encouragement, the arbitrator strictly has his hands or her hands tied. Lack of appeal, well, of course, that's attractive until you lose an arbitration. It seems so attractive, but is it such a good idea? I mean, to my mind, having your work reviewed, or the potential in a rare case to have it reviewed, is actually a rather healthy thing. It improves standards. And furthermore, the absence of an appeal in arbitration is often compensated for by a greater enthusiasm for taking points either on jurisdiction or on due process, which can themselves, if they're taken to court, involve cost and time. Michael is right, I think, in saying that costs in arbitration are scrutinized less rigorously than in court. Theoretically, in the United Kingdom, at any rate, an arbitrator can send costs off to a cost judge for assessment, but I think it would be unheard of to do so. And if you just leave it to the parties effectively to set the level of costs, the truth is that neither side's legal representatives are necessarily going to be very critical of the others. That may be a bit unfair, and I've certainly seen substantial criticism, so I hope it is unfair, but human psychology suggests that it may be difficult to persuade an arbitrator, if you yourself have incurred £5 million worth of costs, that the other side was unreasonable in incurring £5 million in defending your claim. So there are points to be considered about arbitration, and I think my message at the end of the day is that, of course, the arbitration has enormous value as a consensually based system. That's holistic, and it has value because parties can, in some measure, shape what happens according to their wishes. But it shouldn't be adopted on a boilerplate basis automatically and without real thought. It is often the right means of dispute resolution, but where it is, it needs to be adopted on terms or rules which do carefully consider and cater for the actual situations which are likely to arise and which guard against some of the problems which I've mentioned. So I hope that's helpful. Let's open up the discussion from the floor or between the tribunal. What do we all think of each other's contributions? Megan, do you want to?
Yes, I would like to pose a question actually to you in context of sort of the wrap-up of your presentation there. I'm curious what your opinion or viewpoint on either virtual or hybrid hearings might be, and if you see that perhaps addressing some of the challenges to arbitration that you've mentioned, scheduling, time, you do have time change issues, but it could potentially increase the speeds and reduce the costs, and I'm wondering if you think that is something that might be here to stay.
I do absolutely think that's here to stay. I mean, I think that over the last 2 years, it has been quite obvious that we've been missing something in the past, and that in fact you can have very satisfactory remote hearings and very convenient ones, and you can, the only snag being occasionally you have to get up rather early in the morning, but you can dial in people from all over the world, and it can work extremely well, and does work. And I think that the so-called advantages of actually sitting opposite someone and staring them in the eyes are considerably overrated. And if you're examining even a factual witness, but or an expert, it's very often perfectly satisfactory to do it remote. So I think we probably may get away in many cases from a presumption, although I think people will still argue, no, we like an in-person one. But I think arbitration tribunals ought to be quite robust.
Any other general questions maybe from the audience before we...
Having heard what Michael said about the challenges of establishing an arbitration centre in Cayman, do you think there's anything the profession can do to promote an arbitration centre here?
I think certainly one of the keys to getting things going and having a chance starting out is going to be the domestic arbitration, the ad hoc arbitration, getting people into the center, using it and promoting it in that way. And also I think just the feedback, what do people want? What do people need? The consent, choice of parties, that's the key to arbitration. And that's really where it comes from. And I think one of the things that maybe I can see as a challenge in arbitration moving forward is that many of the laws, many of the rules, they are all becoming more and more similar, and in some cases more and more prescriptive. And so I think one of the most important things that we could get is feedback from the end user and the client. What do you want it to look like? What are maybe different ideas to do things differently, or give people more freedom that still achieves an appropriate goal at the end, keeping in mind that resolution of a dispute is the goal of arbitration. Figuring out what we can do and how things can look in maybe some more creative ways to really serve what people want, what people need, and not just, to start an arbitration center here and just copy what London's done, what Singapore's done, what the BVI have done, which are all excellent institutions, but that doesn't make any sense. You can't just say, well, okay, we're different jurisdiction with different geography, that's not enough. I think one of the keys that we had always looked at and thought would be our way of differentiating ourselves 2-3 years ago was that we really wanted to be on the forefront of the technology and these virtual hearings and virtual arbitrations. We were working with the Center for Courtroom Technology based out of Williamsburg, Virginia, that helps a lot of the US courts with their virtual proceedings. And now, in general, the world has caught up to that, which I think is a great thing. The things that are available now weren't available 2 years ago. But I think it's going to be very important to keep looking forward and keep seeing what we can do that's different. And the more input we can get from not just practitioners here, in the Caribbean as a whole, but internationally, to help us figure out what the next generation of arbitration centers should look like. That's definitely going to be the key for sure. And we're definitely open to those sorts of suggestions and would love to get that feedback from people.
There's a question. Justice Siegel.
So as you handed me the mic, I thought the whole thing was being turned off for censorship reasons. But can I congratulate the panel for a series of splendid presentations? I, for one, found them all really thought-provoking and very interesting. I was going to ask Michael which judge it was that he'd offended before, but I've decided to refrain from doing that. It seems to me that there is a consistent message from a number of the presentations, which in particular is that you need to pick the right kind of case for arbitration, and not every case is suitable. And that's obviously an important message. And in this jurisdiction, it seems to me important that Michael's point about, well, at least bearing arbitration in mind, maybe for a suitable case, is something that is worth thinking about. My question is to link arbitration to mediation, and to ask Megan the extent to which the Arbitration Centre is also going to focus on mediation, and to ask the panel members more generally about the extent to which they think mediation, again in the right case and not in every case, is worth thinking about, and the extent to which mediation, again in the right case, can lead to and benefit from, at the end of the day, an ad hoc arbitration.
Thank you. I think certainly mediation can play an important role. I've seen it be a useful tool sometimes to help decide some of the preliminary issues. Again, going back to costs and time being an issue in arbitration or litigation, if you can dispense with some of the smaller issues more quickly and focus the bigger, more complicated issues in the arbitration or litigation, I think mediation can certainly play a role in that. I think it depends a lot on the parties that you're dealing with, the relationship between the two. One of the other areas is sometimes in joint ventures where you might have multiple projects going on, and they really need some sort of final decision on a particular aspect, but they still have a parallel relationship going forward. And for them, just a resolution, an amicable resolution of a dispute becomes very important, so they can continue on with whether other parallel projects they might have. I think that's certainly an area that it can be useful. And that's mediation is definitely something that we would be hoping to develop more in the area and develop more with the Arbitration Center, despite the name. But CIAM, it gets a bit long if you start adding too many letters in. I will say that in my experience, and I'd be interested to hear anyone else's, mediation virtually is much more difficult than court proceedings or arbitration. I do think that in my experience in mediation, just being able to have the eye contact or, more readily be able to non-verbally give someone else a cue in the room that maybe it's time to take a break. When you're on Zoom and you realize you can't actually make eye contact with anyone, that becomes more difficult in mediation, or particularly difficult in mediation. And so from a physical presence on the island perspective, I think that certainly we would hope to have facilities to better facilitate that, and focus more on the in-person and less on the virtual for that. But with the way technology is going, maybe there'll be a better solution for that too.
Just adding one word in relation to the Astana International Financial Centre Court, which I chair or preside over. We pride ourselves on offering a package, and I think if you're thinking of an arbitration centre here, mediation is a very useful aspect of the package. There's a court, in my case, there's a busy arbitration centre and there's a mediation centre, and part of the package which a centre like this will offer is a list of not just the physical facilities, the IT, but also a list of qualified arbitrators and mediators who are willing to assist.
Just one other quick note on that. I think maybe someone can confirm or correct me if I'm wrong. I believe at least one of the commercial courts, maybe Dubai, does have a specific provision where during the court proceedings, you can actually refer certain issues to mediation, and they basically just send people off to go mediate an issue and come right back. And I could see that working in an arbitration context as well, for sure.
There's a question.
Thank you. Just following up actually on Lord Mance's point there about having a list of arbitrators. What I was going to observe for the for my own benefit, because it's a curiosity of our Arbitration Act here in the Cayman Islands, is that the Act contemplates ad hoc arbitrations rather than institutional arbitrations. But it also has a provision and a definition of the appointing authority. And the appointing authority is defined to be either the appointing authority that the parties have chosen as part of their arbitration agreement, or, in default of agreement, the appointing authority chosen by the court, which is slightly different to some other jurisdictions who give the power of appointment to the court. So, for example, in Bermuda, there have been cases where the parties can't agree on the arbitrators in an ad hoc Bermuda form arbitration, so they apply to the court, and the court appoints an appropriately independent arbitrator with relevant experience. The challenge, I think, for us in the Cayman Islands is to facilitate the prompt appointment of arbitrators from an appropriate list to ad hoc arbitrations until we can have a system of institutional appointments being made. And at the moment, just for what it's worth, I've had to design some arbitration clauses. I called up SILPA, and I asked SILPA, the Cayman Islands Legal Practitioners Association, if they had an appointing authority service, and they didn't. There's no local branch of the Chartered Institute of Arbitrators. There is a chapter, but it doesn't have the facility to appoint local arbitrators. So you're left having to identify an appointing authority such as the Chartered Institute of Arbitrators in London or the LCIA, all of whom have their lists, but not a specific group of arbitrators who have a full understanding of Cayman Islands law, practice, and commerce. So to the extent I could sort of ask a question of the panel, I mean, do you think that appointing authority regime is satisfactory? Will it work? And if I can lobby the audience, I would say, shouldn't we design pretty promptly a local independent appointing authority with a local list of qualified international arbitrators?
Well, I think that, from my point of view, looking at it from outside, those are all eminently valid and significant questions, and clearly a default mechanism which requires you to go to court is pretty cumbersome and won't necessarily do more than lead to argument in front of the court about the criteria, trying to inform the court as to the case, and it'll be costly. The more familiar position is the one you touched on, the LCIA position, where the court will, the LCIA court, in other words, that, which is distinguished practitioners, will in fact, in the last analysis, appoint an arbitrator. That seems to work pretty well, and obviously other institutions, the ICC and so on, or the PCA, they have, or ICSID, they have similar provisions, and they at least ensure that within the institution a certain body of information and knowledge is built up, which they can draw on in a way which a court can't do.
I don't have anything particularly useful to add to that other than I agree, and I do think that that's certainly an area to develop and look at further, and would be hopefully an area that as the arbitration center develops, we can help with that. But I think the sooner the better to address that for sure.
Thank you. I was one of the members of the committee that was asked to make recommendations that led to the Arbitration Act 2012. And we spent our time, of course, dealing with the legal issues, some of which have been touched upon today. But the real practical issue that vexed all of the members of the committee is, why would Cayman be a suitable venue for arbitration? No matter what we do to improve our infrastructure, whether that be physical in terms of arbitration centres, communications, whether that be flights, telecommunications, video communications, we will always be bested by London, Stockholm, New York, Singapore. So we always wondered, though we had our remit to do our drafting, how this was going to generate arbitration in Cayman, at least on the international arbitrations, the cross-border arbitrations. On the domestic side, we also wondered to ourselves, well, we are an island community of 60,000 people. The number of domestic arbitrations here is rather limited, and is limited by the scale of our economy and the scale of our population. Does Megan, or indeed any of the other members of the tribunal, have some insight on that was lost on the committee 12 and 14 years ago?
I will certainly try and at least, well, I'll certainly give my opinion on it. One, you can see that the number of arbitrations has increased across virtually all of the centers, particularly over the last couple of years. Some of that may be as some disputes have been pushed back during COVID, so you get a sort of artificial spike as things catch up. But I think that at least in certain areas, there is an increased demand, and I do think that is here to stay, particularly as arbitration and the virtual arbitration, hybrid arbitration becomes more of an option. I think that there are lots of parties that are very committed to arbitration as a method of dispute resolution, and are going to be looking for ways to do or to get through the process more expeditiously, and in more cost-effective ways, or in ways that fit what they are looking for, more tailored to what they want to do. And I think that one of those areas, for instance, and I think Michael mentioned this, the specialization. And one of the areas where I've seen sort of new interest in arbitration, and is just an emerging area in general, is certainly the technology sector. I think that for them in particular, not only is the privacy and confidentiality important, but it becomes incredibly important to have a panel that they can choose that is well-versed and already understands their issues. So you don't have to educate a court on what an NFT is, or the basics of blockchain or cryptocurrency, or these different things. So I think that one of the ways we've looked at, or one of the things that we've considered to sort of generate demand for the center, is to focus on those areas where maybe the other centers aren't as established in those areas. They don't necessarily have those specific lists or specifically tailored rules for that sort of dispute so far. So that sort of levels the playing field at least a little bit when it comes to experience, because some of these areas are really emerging. So no one can have years of experience over us. So I would say that's one way. I also think, more from an anecdotal perspective, certainly from the conferences that I've attended and just practice in general and colleagues that I've met, when it's come up that this is a project that we've been working on and arbitration here, the response has been incredibly positive, particularly from North American, Central American, and South American colleagues and users of arbitration. You know, when it comes to a costs and time perspective, they don't want to have to go to Singapore. They don't want to have to go to London. They don't want to have to go to Hong Kong or use some of these centers in much greater distance from them, different time zones, and that sort of thing. So there is the geographical advantage in that respect. I have talked to practitioners who have been using U.S. options, U.S.-based options, for that reason. It's the same time zone or a closer time zone. They don't have to travel as far, but would prefer to avoid U.S. jurisdiction or any perception of U.S. jurisdiction. And so neutrality is such an important perception when it comes to arbitration and choice of jurisdiction or seat. And I think that certainly Cayman has a reputation that goes back, many, many years of neutrality, of supportive courts, of educated, experienced practitioners. And I think all of those things certainly play to our strengths, or play to a very willing audience and demand for arbitration here. As I said, I think just duplicating another center somewhere else, that isn't enough. But I guess in some ways I almost want to turn the question back and say, what is it that you see that you think Cayman lacks compared to the other jurisdictions? Yes, some of those jurisdictions have more experience or perhaps more established courts, but other than the sort of branding and the perception there, which I think is something that we can catch up to, where can Cayman not compete, especially if we start to have the infrastructure to do it? It is very convenient to get to. You have the great court system. You have a very modern law that supports arbitration. So to me, and in my experience in talking to other users, the appetite does seem to be there. And so I would like to almost turn it back and ask, where do you see Cayman lacking, and where would you like to, where do you think we can't match some of these other centers? And because I also, from a personal perspective, that would be helpful for us to make sure we're addressing those concerns, because if you have them, surely others do as well, and would like the opportunity to convince them too.
Thanks. I'll just say a couple of words. I'll try and sort of be succinct, because I know time is quite short. And it partly goes to Colin's question and also Justice Siegel's question. I think there is actually a lot of disputes, particularly in the financial services space, that just simply are not litigated, because the cost of litigation is very expensive, here as it is similar to many onshore jurisdictions. So I think having an arbitration centre that caters for local work, but also if there is some sort of mediation mechanism, I think that could actually drive a higher volume of lower value dispute resolution. So I think that's one point I'd like to make. And then a mediation that I took part in last summer in Hawaii was going to be pretty amazing. I was very much looking forward to that until it was switched to Zoom. So I think don't underestimate the number of shallow people out there who will travel to a tropical island for an arbitration.
I suppose the risk is that disputes of size often accumulate an international aspect, if only because, for example, lawyers from London or insurers in London employing London lawyers in London get involved, even if it's fundamentally a Cayman Island dispute. And when the arbitration clause is agreed, maybe they're also active, and that tends perhaps as a drag against arbitration in a particular place.
Thanks everyone. If we could show our appreciation for what was a truly excellent panel. Thank you.